Good morning.
How are you, Mr. Newmeyer?
Very well, thank you.
It's been a while. Okay, see, we have Mr. Elliott. Okay, Mr. Newmeyer, it's your turn to go.
Thank you, Your Honor. Mark Newmeyer on behalf of the appellant in this case. This case delves into the totally unambiguous issue of when is a judgment void and when is it voidable. It's a petition for declaratory judgment that we brought to set aside a divorce decree, which terminated my client's parental rights over a child born at the marriage. The basis of the petition and amended petition was twofold. One was we alleged that a fraud had been committed and that there were issues with the consent. When we went to hearing, very clearly we were wrong on that one, and I acknowledge that. However, we also had a second basis for the relief we sought, which was that the divorce decree was void as to the termination of the parental responsibility and parental rights because there was no pleading that raised that as an issue. In the declaratory petition action, the respondents,
Mr. Newman, can I interject?
Yes.
And I see in your brief how you've raised all of these points saying that the court doesn't have jurisdiction, but we all could agree the court had jurisdiction on this dissolution matter. You agree with that, right?
Yes, we do, Your Honor.
Okay. And you also agree that in this case, your client consented to the termination within the purview of this dissolution case, correct?
He executed a document that purports to do that. Yes, Your Honor.
Okay.
Yes.
And so with that, regardless of whether or not, that termination was induced by anything else, and I know we have to deal with the statute of repose and all that, but because he agreed, the court had ultimately that you look at is the overall jurisdiction. If the court had jurisdiction over this dissolution proceeding, and part of this dissolution proceeding, the court gets to determine the children and whatever, and if there's a consent by one of the parties to termination, why isn't that appropriate jurisdiction under those facts?
Because, Your Honor, termination of parental responsibility was not pled for, and it is a separate cause of action. It has separate issues. There are separate pleadings that must be made in order to do that. In fact, normally there has to be a guardian ad litem filed or appointed and so forth and so on. It is not the same. You cannot just file a petition for declaratory judgment, ask for child support and parental responsibility to be determined, and come out of that with an order terminating parental rights without.
And you may be correct, Mr. Newmeyer, if you're dealing with a situation where there was no consent. I mean, obviously, in a dissolution proceeding, the court can't just say, oh, by the way, I'm going to rule that you, Dad, terminate your rights. But we're not dealing with that. We're dealing here with a consent. And let's just assume, for the purpose of my question to you, that no issues of fraud, no issues of whatever, that the actual party agreed to something which is well within the court's review, a jurisdiction.
Right.
We're not dealing with a separate, and you are correct, the trial court doesn't have the authority to simply say, I don't like the way, Dad, you're treating this, I'm going to terminate, without any pleadings. But within the context of this particular case, where there's a consent by your client, that's what I'm having a hard time with.
Yes, Your Honor. And that's why I need to go back to the case law. Just because the court has general overall jurisdiction of this does not mean it can decide any issue within that general and overall grant of jurisdictional authority. And that goes back to the Lovett case. Lovett was very clear on this issue, and it actually was issued in 1927, clarifying the Moses case from the previous year. And in that order, in that opinion, it addressed this specific issue of when does the court have subject matter jurisdiction. And it had assuming there's no race to be dealt with, no land or whatever, 3 remaining issues. One is it has to have that general overall jurisdiction over this class of cases. Number 2 is that overall jurisdiction must be invoked by the filing of an appropriate pleading. Number 2. Number 3 is there needs to be notice to the party who's been subject to process. Okay, so there are 3 requirements there. The problem is that over the years, as I've cited in my case, a lot of the case law cites number 1 and number 3, but doesn't mention number 2. It's not because number 2 is not still good law that you must, in order to invoke jurisdiction, you must have appropriate pleadings. And keep in mind, you cannot stipulate to jurisdiction. You can't. It's very clear.
Mr. Newmeyer, you can waive a failure to plead and try an issue by consent, can't you?
You cannot, Your Honor, and that's the Levitt case.
You're suggesting that you, for instance, you can't conform pleadings to the evidence, or again, stipulate to a court deciding an issue?
Your Honor, what you can do is stipulate to the relief, and then what you have to do is amend your pleadings to include the new relief being requested pursuant to Levitt, and then move forward. That's all that has to be done. Or you can file a motion for leave to amend the pleadings. If it's granted, it would show up in the final judgment. That was not done here. You can conform the result. Excuse me. You can enter the order conforming to the evidence, but you cannot conform the evidence to impose new and unpled for relief.
Well, let me ask you this question. How this was a petition for dissolution of marriage where the parties had a minor child. Yes. How could the court not have dealt with the welfare of the child?
Dealing with the welfare of the child is absolutely on the table. But that is not the same as a termination of parental responsibility. And this is not an argument, of course, that the court made below. My argument was this order is void because you need 2 things, assuming the party is in the case. You need a pleading. There's no free-form judicial authority to just, all right, I know you're here, on a contract case, but I'm going to declare your grandchild dependent. You can't do that. You can't raise issues that are separate than what's in the pleadings. You also, and even if the parties stipulate to that, you still have to have a pleading, some basis for it, according to the Levitt case. And I understand that Levitt is an old case and it doesn't get a lot of attention, but it is still frequently cited in the case law. And I'd like to point out the reason for that is opposing counsel argued in this case that the DPP, INRI DPP, that adoption case, and also the Martinez case, another adoption case, the court made the finding and stated the rule to be, well, if you have overall jurisdiction of this kind of case, and if you have notice or, whatever, some kind of appropriate notice, then the court has the right to enter the order and the resulting order is not void. Why didn't it mention about the necessity of invoking the jurisdiction with an appropriate pleading? It's because in both of those cases, there was a petition for adoption. It wasn't an issue in those cases. And this is part of the problem when you have a case doesn't deal with, pleading is not an issue. So they state the rule and ignore the part of the rule that deals with an appropriate pleading needing to be done. Turning this on its head is like this. If the court enters an order that grants relief that was not requested, isn't that a void order? That's what the case law says. So you have to come at it from both directions. Number one, assuming that you have an appropriate jurisdictional field for the court. Number one, you have to invoke the jurisdiction of the court by having a pleading. Judge just can't do stuff on his own. Number two, you have to then give appropriate notice or get a waiver or whatever. So in this case, they did get what looked like an appropriate notice, an appropriate waiver. So absolutely they did. That was there on the face of it, but they never amended the pleadings. Is that a mere formality? The Supreme Court says no, it is not a mere formality. It is necessary for the exercise of jurisdiction by the trial court. You cannot stipulate to jurisdiction. There's a lesson here, Your Honor, and it's a lesson for both sides and for all practitioners, which is don't cut corners when you're dealing with due process rights. If you get a stipulation and the stipulation covers more relief than is set forth in your pleading, amend your pleading. It's easy to do. It's to be liberally granted. You ask for your pleadings to be amended to include the additional relief. You serve that on the other side. You give them new notice. You get a new waiver, and then you move forward with it. Instead of, like here, cutting corners, getting new and additional relief that was never contemplated in any of the pleadings before this waiver came in, and then taking it straight to the court without allowing the court to assume jurisdiction over that issue. And I would point out that this is the way that the case law has grown over the last 100 years. It all fits together if you look at what is required to be done. Number one, if you don't amend your pleadings and you grant relief that was not pled for to invoke the relief of the court, the resulting order is void, and you can attack it at any time. On the other hand, if you make a stab at obtaining the new pleading, like you plead for termination of parental responsibility, but you miss one of the factors, one of the elements, there's some kind of a procedural or a technical defect. The case law deals with that situation. It says, wait a minute, you tried to amend the pleadings, you tried to invoke the court, therefore, this order that results is not void, it's voidable. You can only, and there are restrictions on how long you have to try and attack it. You can only do that for the first year. Whereas if it's void.
I guess I'm having a hard time because you're arguing jurisdiction.
Yes, Your Honor.
But then, and you're saying jurisdiction, but in reality, you're saying a pleading defect. And so they're two very different. So the question for us, does the court have jurisdiction in this case? And I think we could all agree the court does have jurisdiction over this dissolution proceeding. And so, and I could go back to my initial question to you, the fact that a party agrees or stipulates or consents to something, it's almost similar to, okay, you have a lawsuit dealing with two people that are breach of contract, and then they resolve the case and there's a consent judgment as to an injunctive relief. The injunctive relief is not pled, but the parties agreed to it. They consented to it. It deals with a breach of contract. Are you saying that in that case, oh no, it can't go through? They needed to plead that injunctive aspect. I'm just having a hard time, given the scenario here. Jurisdiction is far different, in my opinion, than pleading.
Yes, Your Honor. And this is why I'm pointing out that the Lovett case has been overlooked in much of the litigation. This is not a pleading defect. I would have to disagree with the court on that. This is a pleading absence. There was no attempt to do anything with regard to pleading for termination of parental rights. There's a lot of case law that says if
I may ask a question, but by no means am I suggesting that it's a pleading defect. I'm taking the position, at least based on this record, I believe, and I'm mentioning this to give an opportunity to address this, that the court does have jurisdiction in this matter. And in this case, by virtue of the fact that the father consented, I think it's well appropriate for the court to do what it did. And I'm still having a hard time, even with the Lovett case. Why should we set aside this? The court does have jurisdiction. And I think you're suggesting that it's a pleading problem. And because there's a pleading problem, somehow the court loses jurisdiction of a matter. This is what I'm concerned with, if I may.
Yes, Your Honor. And again, it's not raised that often. It is raised, for instance, in the Florida Power case that we cited, there was an absence of pleading. And two things. First, as I started to say, if there's a defect, if you attempt to plead something, but you don't do it all the way, the Florida Power case kind of addresses that. It says you don't have to plead it so well that it would even pass a motion to dismiss. You just have to kind of make an arguable attempt to do it. And if you make an arguable attempt, we're going to look at it and it's most likely voidable. But it's also very, very clear. And, you know, we have the citation. We may not use it very often, but it is the law that has never been reversed and is still being cited in the cases where there is an absence of pleading, which is, and I'm going to quote it just for the record, so that when it says a court has jurisdiction of the subject matter of any given cause, if these words are to be given their full meaning, they imply, generally speaking, one, that the court has jurisdictional power to adjudicate the class of cases to which such case belongs, and two, that its jurisdiction has been invoked in the particular case by lawfully bringing before it the necessary parties to the controversy. Number three, the controversy itself by pleading of some sort sufficient to that end. And then number four deals with in rem jurisdiction.
Mr. Neumeier, you did not mention whether you wanted to reserve rebuttal time, but you were down to 4 minutes. So
I am.
Proceed as you wish.
Let me reserve 2 minutes, Your Honor. Just very quickly, this came before the court on a motion to dismiss and a motion for sanctions. It's our position, again, they're saying there's no case law that deals with this issue. There's Supreme Court case law, and it is frequently cited, including in Florida Power and a number of other cases that I've cited in our initial brief. What then came to the court's attention is, well, if it's voidable, then the statute of repose would absolutely bar it, no doubt about it. But if it's void, does the statute of repose act to render this order valid due to the passage of time? And we would argue, based on that entire case section that I have in my brief, if it's a void judgment, statute of limitations, restrictions, rules, statutes, anything that purports to say, no, after so much time goes by, a void judgment becomes valid, that cannot be of any effect. We believe that the trial court erred in not examining whether this was a void order or not, simply entering a ruling. And we believe that based on the Supreme Court case and the ongoing cases that cite it, a failure to plead, regardless of consent or agreement, divest the court of jurisdiction. Sounds like a big revolution, but it's been the law in Florida for the last 100 years. Thank you.
Thank you. Mr. Elliott.
Good morning. May it please the court, Tom Elliott on behalf of the appellees. I think I heard the concession that that there's no fraud and that the 1-year repose would bar this claim. And there's a purpose for that statute, is to, and we talk about that in the brief, to provide stability. This is a situation where you have a child born in September of 2017 and the parental rights are terminated in August of 2019 before the child is 2. And this claim is then not brought until May of 2022, 2.5 years later. And here we are now with the child 6.5. So the point, and I look back at the reply brief just now, that is overlooked by the other side or ignored. And as a point you raised, Judge Northcutt, Rule 1.190B, or we're in family law, 12.190B, says, refers to amendments to conform with the evidence. When issues not raised by the pleadings are tried by express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. Here we have the termination of parental rights tried by express consent. He signed a notarized form saying he was giving up those rights. So it was tried. It is deemed amended. And that really is the end of the discussion. I've got a lot more I could say, but let me pause and ask if there are any questions from the panel.
Not of this, but Mr. Alka, let me let you jump to the sanctions part of it, a part that kind of concerns me a little bit. In this court, as I understand, that the court granted sanction as to entitlement only,
Yes.
and it did not include an amount to be imposed. Isn't that kind of premature at this point?
I think, Your Honor, if it was a standalone order on fees, on entitlement, yes. I think there is case law that when you're bringing up the another issue, you can tag on the entitlement finding to it. But the only argument that's been made on entitlement is, well, we were right on the first part. Our argument is right, so we shouldn't have been sanctioned. That's how I read the briefing on this, and that we would say, no, you're not right, and the trial court was right.
Yeah, assume that we affirm the trial court's decision, the court has jurisdiction, proceed with that. It's a sanction part of it. It's like, shouldn't we basically dismiss that part of the appeal regarding entitlement to sanction because it is premature? We don't have a monetary amount yet that has been imposed.
And I understand the case law is very clear that if you had just the sanction order standing alone, that without an amount, you would say that's not ripe yet. But I think there, and I'm not sure if we cited it in the briefs because there really was no argument in the reply brief about this, but I think there is case law that if the sanction finding, or if an entitlement, let's just say an entitlement finding the fees comes up as part of the case, even though the fees have not been awarded, that the court can review that. I don't know that we cited a case on that because they didn't raise that as an issue.
I appreciate Mr. Ecker. That kind of concerned me a little bit, and I wanted to have the opportunity.
If you'd like, we could look for that and file something on it. And if it should be dismissed, we'll tell you that.
Okay, thank you. Thank you.
Are there any other questions? In that case, we would ask that you affirm. And let me get to, I had a couple notes on that. Because the appellant consented and then waited over 2.5 years, that's well past the 1-year limit that exists to protect children and to provide stability. This judgment should be affirmed because it's correct and because this 6.5-year-old child's life should not be thrown into chaos at this point. So we would ask you to affirm. Thank you.
Thank you, Mr. Elegant. Okay, Mr. Neumeier, you've got 2 minutes for rebuttal.
Yes, just 3 points I'd like to make. Number one, this was denied by a motion to dismiss. So this is not, hey, if you reverse it, the kid is going to be destabilized. This is just the beginning of the procedure, which we believe is proper. Number two, counsel misspoke. He said there was a notarized form. The form was not notarized. It was obtained from my client while he was in a psychiatric facility and signed. Number three, the court does have the right to amend pleadings, and all they had to do was ask for that here. That's my point. It's easy to do. Then you don't run afoul of Lovett. Instead, they are putting all of their argument on the fact that in cases that did not involve issues with the pleading being absent, the courts in those cases didn't mention pleading being necessary. It is necessary, and I understand that's somewhat counterintuitive. Doesn't make a lot of sense, but we deal with the law as we find it. I would ask that if for any reason the court affirms on this case, well, at that point, we would be asking the court to cert this, whether in fact there is a, whether Lovett continues to be the law or not. Thank you very much. We're asking that you reverse this and allow it to go back past the dismissal stage to proceed to determination by the court. Thank you.
Okay, thank you both very much. In order to leave our virtual courtroom, you need to click the button called Leave.